statute requires published notice and notice to be posted at the municipal building. Those acts, as far as I am aware, were completed prior to the vacancy board meeting on, the dates are escaping me.
Whenever
I believe it was April the 29th. There has been an allegation that's been advanced, both by Mr. Caro and others, that because there was not sufficient opportunity made for the public to comment upon Ms. Hoyer's, or the question of who to appoint to the vacancy prior to the board voting to fill the vacancy, that constitutes a Sunshine Act violation. I am certainly not going to go on record answering whether it does or it does not, because as you well know, Mr. Caro, that is presently the subject of litigation before the Court of Common Pleas of this county. And I'm not going to put the township in a position one way or the other of attempting to pre-answer the question that's before Judge Mellon for hearing on Thursday of this week.
Okay.
Well, Mr. Savone, I would also ask you to clarify, as several of us present were in the courtroom that day, wasn't the original charge or the hearing that was ordered subsequent to the illegal ex parte injunction by Judge Mellon, wasn't that withdrawn by counsel Mike Fitzpatrick, who really is the one that brought this case in the first place?
As the board is aware, just to sketch in the procedural details, at the board meeting subsequent to the vacancy board's meeting to appoint Ms. Hoyer, Mr. Caro and Mr. Leonhauser called for a re-meeting of the vacancy board, which, as you are well aware, is permitted under the Act. Any Commonwealth agency, any state agency, any local agency can meet and ratify or endorse their prior action and cure any alleged violation of the Sunshine Act. That motion was defeated in this board, but a meeting of the vacancy board was called by the chairman of the vacancy board, which is his right to do under the second-class township code. That meeting was scheduled for May the 9th, Friday. That was the last day on which the vacancy board could meet within their grant of authority under the second-class township code. Prior to that meeting, which was scheduled for 5 o'clock, at approximately 3 o'clock that afternoon, Mr. Fitzpatrick, on behalf of a number of individuals, Phil Schieber being one of them, that's the only name I recall, I think Mr. Gallagher may have been involved, Michael Gallagher as well, obtained an ex parte court order from Judge Mellon enjoining the vacancy board from meeting that evening. There had not yet been a meeting. I can attest that it was ex parte because I was 325 miles away in Pittsburgh, and I got a phone call after the order had been signed indicating that the judge had stopped the meeting before it occurred. The reason was there were allegations that there wasn't adequate public notice. We went to court that following Monday, and after some rather vigorous arguments, the request for the injunction was withdrawn by the applicants.
And I'll paraphrase or summarize what happened. The request was withdrawn by the attorney who brought it, Mike Fitzpatrick, because it was completely without merit. In fact, did not Mr. Fitzpatrick make some pretty ridiculous arguments trying to prove that there were Sunshine Law violations and embarrassed himself in that court?
As to the May the 9th meeting, the Sunshine Act is a statutory creature. It creates certain rights and certain responsibilities. The remedies that are provided under the Act are also statutory in nature. So it's not like a case where you can go generally to get an injunction from stopping something that's a grave harm or a likely harm. You have to fit within the definitions of the Act. The Sunshine Act, as Judge Mellon concluded, requires that there be a violation before anything can be done to remediate the violation. By obtaining a court order to stop a meeting that hasn't occurred yet, there actually hasn't been a violation. No violation could have occurred until the vacancy board met on May the 9th and voted in a way that was inconsistent with public notice. Because the petitioners, Mr. Fitzpatrick, went to court to get an order to stop it before it ever occurred, he necessarily eliminated the possibility of a Sunshine Act violation, which obviates the need for the injunction. When that was pointed out in court the following Monday, the judge agreed, and it was then that Mr. Fitzpatrick withdrew the motion because it was not authorized under the Sunshine Act and in fact had been preliminary in nature and there was no violation to cure.
And that decision was made after a meeting in chambers of Judge Mellon, correct?
That's correct.
To keep you out of it, I will just say that an honest judge with integrity, a judge other than Robert Mellon, would have just dismissed the case out of hand. You don't have to agree with that.
I don't agree with it. Anyway, let me answer Mr. Thompson's, you had a question to me. I started out by saying that this is about public trust. And I feel that the public trust was eroded at that vacancy board meeting.
In what way?
Let me finish, okay? And by